The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about the responsibilities of a trustee when selling real estate. So, if you're the trustee of a trust, there's usually beneficiaries named in any trust whose interests you as the trustee are supposed to look out for in all of your transactions. If you have real estate that's owned by the trust, you have to make sure that you do what is in the best interest of those beneficiaries and follow the terms of the trust. So when you're a trustee, the first thing you want to do is look at the terms of the trust to find out if the trust tells you how to deal with any real estate or other assets that are involved. And if the trust tells you what to do, then that's what you should do. But a lot of times trustees are in a situation where they have assets to deal with, beneficiaries that need those assets distributed them. The trust just says distribute the assets to these three beneficiaries equally, and the trustee has to figure out what to do with that asset. And really there's a couple different options with real estate. One is that you can maintain it in the trust and charge rent to a renter and pay the rent either to the trust and reinvest it or pay it to the beneficiaries. Another option is to transfer the real estate to one or multiple of the beneficiaries and basically reduce what they're going to be getting from the rest of the trust based on the value of that real estate. The third option is just to sell the real estate and transfer the proceeds back to the trust or distribute them to the beneficiaries. So I don't want to get caught up in whether you should be distributing to the beneficiaries versus reinvesting in the trust. Usually the terms of the trust will let you know what you should be doing there, and the age of the beneficiaries matters too. But really, how do we want to deal with this real estate? Do we transfer it to the beneficiaries? Do we sell it? How much do we sell it for? The important thing to know is that whenever you're dealing with any distributions of a major sort, of a major asset in a trust, we recommend that you always get written consent of the beneficiaries or the beneficiaries' legal guardians before you make any major decisions and make any major transactions. So this means that find out if one of the parties wants to own the home, and if they do, get the consent, build a consensus among the other beneficiaries and get everybody to sign off on the transaction if you're going to transfer it to one of the parties. If you're going to sell it, before you actually sell the property, get everybody to sign off on the fact that it's being sold and the sale price. The reason that we do this is because if you make a transfer or sell it without getting everybody's consent, then you're opening yourself up to potential personal liability. One of the beneficiaries can claim that you didn't follow the terms of the trust or that you transferred the property for less than fair market value. And if that happens, let's say fair market value of the property was $300,000 and you transferred it to an insider, one of the family members, for $200,000, or offset their inheritance by $200,000, then you might be, as the trustee, personally liable for the $100,000 difference between fair market value and what you actually transferred it for. So the trick is, make sure before you make any transfers, you get everybody's consent. If people disagree about what should be done, I would rather you go to court beforehand, before you make any transfers, and let a judge decide what should be done with the property, rather than do a transfer and now suddenly you might be personally liable if you did something that you shouldn't have done. I'd rather have a judge decide what to do in advance than decide whether you're personally liable for something that's already happened. So to summarize, there's a couple options with the property. You can transfer it internally to an insider, you can sell it, you can hold on to it, charge rents. Whatever you do with it, just make sure you build a consensus among the trustees, get it in writing that it's okay that you're doing what you're doing. Among the beneficiaries, not the trustees. And then if you can't get a consensus, go into court and get a court order approving whatever you plan to do. And when you go into court, this often means opening up a probate case, and that's unfortunate, but that's better than accruing personal liability. So I hope you found this helpful. If you have any questions, please feel free to leave us a comment in the comments section at learn-about-law.com right under our post or under our YouTube video, and we'll try to respond within 24 hours. Feel free to give us a call at 630-324-6666 to schedule a free consultation. And if you find this helpful, please subscribe to us on YouTube, SoundCloud, and iTunes. Thanks so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.